Chair calls Shelby Sharpe, testifying for House Bill 93 on behalf of himself.
Thank you, Mr. Chairman, members of the committee. When I graduated from the University of Texas School of Law, I went to work for Chief Justice
Give us your
Robert
name.
Shelby Sharpe.
Thank you.
I'm sorry, I thought I did. Excuse me. When I graduated from the University of Texas School of Law, I went to work for Chief Justice Robert Calvert at the Supreme Court of Texas. And since I left that court, I have handled a lot of constitutional law issues, many times before that court in the Supreme Court of the United States. Some years ago, it was brought to my attention, a lady came to me and said, my husband sued me for divorce. I'm not a family lawyer. She says, well, I think there's something wrong that you can't defend yourself. I said, well, due process has 6 elements, and marriage is a constitutionally protected right. But I looked at it, and the last 2 elements are not there. One, that you can either prove a defense that bars it, or you can prove there's no merit in it. Neither of those is possible. Now, let me explain to you real quickly. No-fault divorce came in 1970. At the time it came in, the divorce rate in the United States was 1.5 and had descended from 3 point something to 1.5. When I grew up, I only knew a couple of kids that their parents were divorced. I only knew a couple of adults that were divorced. But since no-fault divorce came into effect in 1970, and by the way, there's not one single study on no-fault divorce that has found that it was good. Not one. All of them have found these consequences. 1, it has put more women and children in poverty than any other single piece of legislation. 2, it has caused, and by the way, y'all are concerned about the budget? In 1970, in the public schools, there were no remedial courses, period. There were courses for children who were learning disadvantaged and had problems, but since then, the remedial courses have shot through the roof, and guess what? They're populated 100% with kids from a broken home, 100%. So you've increased that. When I went to Fort Worth to practice law, there were 2 family law courts. There's a whole building now of family law courts there, and it dwarfs the civil district courts. So you have exploded that and added that to your budget. So look at the poverty part that you've increased as a result of it. Look at your public schools cost. Now, also look at the health costs. The studies are absolutely irrefutable. They've increased those. Look at your crime rate. You can also show empirical studies. So, since 1970, when it was 1.5% of families, you've created this problem. Now, here is the real interesting thing. The first Supreme Court of Texas, Chief Justice Hemphill, writing an opinion, said if divorce were permitted for little or no reason, here's what would happen to the culture. And he described in explicit detail what we have today. And here's what his final statement was. He said, yes, divorce should happen, but only for reasons, solid reasons, approved by law. Because when people know they can't just get a divorce for any reason, they become good husbands and good wives. And from 1848 to 1970, he was right. And from 1970 on, he was right on the consequences. Thank you very much.
Thank you, Mr. Sharpe. Any questions? I think Mr. Sharpe.
Mr. Sharpe.
Mr. Sharpe, would you come back? I think Mr. Schofield has a question.
The chairman got you to state your name, but I'm not sure you ever stated your position on the bill.
I am for the bill, and I was speaking on the bill and for the bill. Because Matt's bill solves 2 problems. 1, it gets rid of the due process problem, and 2, it begins to help minimize the consequences that no fault created, so that you're not going to have continuing increases in all the areas that came out of no fault.
So you want to be listed as being for the bill?
Absolutely.
He is listed that way.
Yes.
And I said, you know, when I listened to your testimony, I guess I couldn't help but think that you think we ought to make it more difficult to get a divorce, period.
You just should go back to the fault system that worked so well. I mean, nobody came along and said to the legislature, hey, You need to go to no-fault divorce because the fault system is not working. Nobody gave that testimony. And we've seen since the problems it's created that the fault system did. All I'm saying is, hey, look, if you did from 1848 to 1970 something that served the people of Texas so well, and now you've created this monster, why not go back to it? Common sense says you go back to it.
Well, suppose we did this. And I was just thinking this based on the testimony. Suppose we did insupportability only as a consequence where it's consented to by both parties.
Nothing wrong with the parties consenting to it. No
Okay.
problem about that. The due process problem is if I have a constitutional right and you can take it from me and I have no due process, that creates a problem.
Yes.
By the way, do you realize this is the only law that's ever been passed where the defendant cannot win? You want to put that over in workers' comp? You want to put that in tort cases where the defendant can never win? Whoa! You want to put that in med-mal cases where they can't win? But this is the only one where they can't win.
I think Mr. Kane has a question.
I like that you're where you are on due process. I believe in the beginning you kind of maybe mentioned 6 elements and said there's 2 elements not present here. Could you explain those or describe them for me?
The 2 elements is that 1, you have to be able to prove a legal bar to the divorce, or 2, a lack of merit in the claim. Those are the final 2 elements of the 6 elements the Supreme Court of the United States say make up due process. The first 4 elements are all there. In other words, notice, right to have counsel, right to be able to call witnesses, right to be able to put on proof. 2, do 2 things. 1, either show a legal bar, which there is none, or show a lack of merit. By the way, when I handled that divorce case back sometime as a constitutional issue, I got the certificates of 175 of the 254 clerks that divorce cases were filed. From 1970 to 1993 when I handled that, they told the number of cases filed and the number of cases not dismissed for want of prosecution that went to a judgment. The plaintiff won every one. Now that is irrefutable proof that this violates, and by the way, every constitutional lawyer I've talked to, not family lawyers, they've said this is a no-brainer. Thank you very much.
Mr. Dale has a question, I think.
So has anyone ever brought a constitutional challenge to this? And?
At the end of the trial, the judge dismissed his court reporter. I had filed a brief, and the judge says, Mr. Sharpe, you're absolutely right. This thing does violate it. Opposing counsel, the petitioner, he said, Judge, I couldn't file a response because he's right. And the judge says, but I want the appellate court to tell me personally, it's unconstitutional. My client, and I was, by the way, pro bono, didn't cost him a penny, but he decided that he didn't want to carry it any further. If I could ever get somebody that would let me get into the Supreme Court of Texas with this on no fault, I know that court well enough because I've been before them a ton of times on constitutional issues. They would say it's unconstitutional. If I get before the Supreme Court of the United States, they'd knock it out in all 50 states because it's a patent thing. Nobody has got a case that supports them on the due process part of it. It's just not there.
I think Ms. Theory has a question.
Yes, ma'am.
Yeah, so just in terms of just a practical application, just for the benefit of all of us here and people listening, I want to ask you just a couple of questions in terms
Sure.
of real life situations.
Absolutely.
For example, if a woman is married and she's the victim of, for example, domestic violence for several years, would your position be that she filed a divorce saying she's the victim of, and let's say it's even, let me change that one, let's say it's mental abuse, emotional cruelty. What is your proposal to have her do if she would like to get a divorce from this man that she's married to? And from the due process standpoint, are you saying that she would need to prove beyond a reasonable doubt in a court of law that she's
No,
the
not beyond a
victim
reasonable
of,
doubt,
well,
by
at some point,
preponderance of the evidence.
preponderance of evidence
Yeah.
that she is the victim of mental abuse or emotional abuse.
Just like it was from 1848 to 1970. And see, one of the good things about Representative Krause's bill is those things are going to be redacted, but you still have the burden of proof. Anytime I go into court as the plaintiff, I have a burden of proof for my client to win, and the defense has the ability to show I don't, or to come up with some type of legal bar. But no,
Okay.
that would be the same as it
So
was from
what- in the-
1848 to 1970.
Okay, so at the end of
No
the day,
difference.
would the outcome be okay if she was still divorced? Or is the goal for this person to stay married to someone that they feel they're being abused by, or they
No.
are being abused by? Or is it just to, what is, if the
As
outcome
Chief
is going to
Justice
be the
Hemphill
same?
said, reasons approved by law where you show adultery, physical abuse, mental abuse, abandonment, those were all good grounds, and divorces were granted in Texas all during that period of time. Really, we're not changing anything. We're just simply getting rid of the due process part and going to what the law was from 1848 to 1970. It was nothing new. I mean, we got over 100 years of judicial precedent on
Well, I
it.
bring that up because I know the National Organization for Women was behind a lot of the changes for the divorce laws back in the time period you're talking about in '69, early '70s. And a lot of it had to do with women being battered and fleeing and being in very, very physically threatening
But
situations.
divorces were granted in those cases and should have been.
Well, and that's my question. That's my question. So back to the pattern. If, for example, I were being abused and no one knew it but me, and by the time I file for my divorce, it's not as though my arm is broken or what have you, would your position be that if I didn't have the evidence to show that I was being physically beaten, that if my husband came forward and said, that's not true, I'm a nice person, I don't beat my wife,
That's
If
what
the
a jury's
judge-
for, is
right.
to decide that.
So-
A jury's going to determine, is she credible or not, and if they go with her, bang, she's got the divorce.
and if they go against her and believe that...
It's like any jury trial. Sometimes you can be right and the jury can get it wrong.
Right. So hear me out.
Okay.
So in that situation, if the preponderance of the evidence, or as if it all turned out that they didn't believe that she was being abused, you would have her stay married to that person?
You're going on what the law says you're entitled to
Right.
recover. That's all it is. Like I say, this is not new law. This is 1848 to 1970 Texas law that, by the way, when I went through law school in 62 to 65, this is no different than any other case. I mean, I can have a med-mal case and go in and the jury goes against me. I mean, the person doesn't win. They don't lose.
All right, but with all
Now,
due
does that prevent her from separating from him? Heavens no. She didn't have to stay married to him, but she can separate from him if there is an abusive situation. But by and large...
Well, from a financial standpoint, I'm sorry to interrupt you because you didn't let me finish the hypothetical. From a financial standpoint, we talked about how costly divorces are. If she's a person that's being abused, you're saying that she should put on a full trial that could potentially cost hundreds of thousands of dollars, could take a year and a half, deposing her husband, trying to bring witnesses into the
No, I'm not
case.
saying
Because
that.
that can be very expensive. And let's say this is a person that doesn't have the resources, and so you're saying she can flee and separate, but then again, that's still her husband. That means she'd be without community property, all those other things that come from the result of dissolving the marriage. So I'm just asking for that type
Okay,
of a
let me say this.
situation.
For every extraordinary situation like you've got, you have extraordinary situations in every area of law, every one of them. And there are lawyers out there who will do pro bono work. There are lawyers out there that will do it. Hey, when I do pro bono work, my normal rate people couldn't afford it, but I do a ton of it. So you can have an isolated situation, but you've got to look at the big picture. And like I say, my paper that will be distributed, you look at Chief Justice Hemphill's comments about that. And hey, an extraordinary situation shouldn't drive legislation. Legislation should be driven by what is the best for the public at large. And we've got, let's put it this way, I'll put the 1848 to 1970 experience under fault system against what's happened since 1970, and you determine which serve the people of Texas better. And I'm sure during those situations you had some bad situations and some people who got injustice, but that's a part of a system that when you got human beings, injustices will occur from time to time.
Well, I think domestic violence is on the increase. I wouldn't quite agree that it's an extraordinary circumstance. It happens quite a bit. So that was just the one fact pattern I was giving.
And by the
in
way,
terms of that.
domestic violence has only increased since 1970. You didn't have that domestic violence at that level prior to 1970. Go back and look at the criminal side of it, because remember, a lot of what you're talking about, those are criminal acts, and they're actionable in the criminal courts. and the state pays for that.
Okay. I think Mr. Moody has a
Well,
question.
Mr. Chairman, I think
Oh, I'm sorry. Were you first?
go ahead.
I'm sorry. Mr. Schofield has a question first.
You seem to be someone who has studied the prior law prior to 1970. Am I correct in that assumption?
Correct. I've studied this area from a constitutional point of view. Plus, I've read everything that's been written on marriage and divorce and the consequences coming out of it to see if it also supported going back to a false system.
The hypotheticals that my colleague was just proposed, in which people weren't able to prove their case and get out of, was that common? Did you find a lot of cases where people were unable to prove the grounds that they were trying to prove to get a divorce?
The only thing you can find going back is looking at the appellate opinions. And you find appellate opinions showing that a decision down below got reversed because the appellate court looked at the evidence and says they got it wrong, and the appellate court corrected it. So as far as our whole judicial system goes, trial courts, vast majority of time, get it right. Occasionally they don't, and the appellate court system a lot of times gets it corrected.
Now today, we have things we didn't have in 1848. Today, there are recordings. There are all kinds of different ways to prove a case. Would you say it's easier to prove your grounds today than it would have been in 1910?
No, the burden of proof proof is based on witnesses. And witnesses, people, I don't think have changed since 1910 to today. People are still people. Now, is there electronic stuff out there that might be available to come in court today? Sure there is. There's lots of stuff on that side. But in a domestic matter, you're talking about two people in a relationship. There's going to be usually a tangential family that's also involved. There are going to be neighbors and friends of these people. And a lot of times, you go back and look at those divorce cases where they were coming in on fault for physical abuse. You had not only the person abused, but you had family members, you had friends, and sometimes children. And those cases got proved up. It's rare that you're going to have abuse and a court or a jury just say, nah, we're not buying that, we're going over here.
So is it your opinion that that if we were to pass this bill and more people were to file based on grounds than file currently based on grounds, as opposed to just insupportability, that it would be difficult for people to prove their grounds for divorce?
No more so than it was from 1848 to 1970, and no more so than I have in all the other cases I've got. Burden of proof in a divorce case or any other kind of case is no different. It's all on witnesses and documents as a general rule.
Okay, thank you.
All right. I think Chairman Moody was next.
You used a phrase in an answer to Representative Theory's hypothetical about the defendant in that case prevailing when there was an accusation of abuse, and you said that in that case the couple would have to remain married, and your response said the defendant would have a right to recover.
No, I said...
right to recovery is what you said.
Well, excuse me, if I said that, I didn't mean to say that.
Okay.
What
it
I'm
sure
saying,
does make the spouse sound like property.
No, heavens no.
Okay.
You've got the fundamental issue in a divorce case is the marriage going to stand or is it going to be severed? That's the issue. And if you prove under the fault system as existed, the grounds, legal grounds, and you come forward with sufficient proof, it's going to be granted. That's it. Now, if you don't prove that
I appreciate your clarification. The other point is, and you talked about domestic violence and the increase since 1970. As someone who has personally prosecuted hundreds of those cases, it is not that they were not happening prior to 1970. Investigation and prosecution of those cases were impeded because people were not given the proper mechanism to bring those cases. Law enforcement didn't take these cases seriously. Women were not taken seriously in these cases. In fact, that actually went further than 1970. It was only till probably the last 2 decades that prosecutors and law enforcement in this state and other states have focused on domestic violence and bringing those actions, and that's probably why you've seen an uptick in those actions, because we're actually taking them seriously for what they are. And so I would caution you to say to bring some kind of link between these two things in the 1970 time marker that you pointed out, because the two should not be tied together and equated. We are doing a much better job today of giving a voice to people in a home who had been silenced for very long, and we need to be very careful about tying these things together. I appreciate your testimony, but I had to clarify that point.
And my suggestion is take a look at the studies on domestic violence, the studies that have been done over the period, and let them speak for themselves. Because they go to, and I agree,
I think
law
Mr.
enforcement
Kane has
needs.
hold on,
should have done
Mr. Sharpe. I think Mr. Kane has a question.
For sure, we're going to bring you back kind of maybe
And
to
we're gonna move on,
the last two questions that Mr. Schofield had asked you. And because I don't believe that he was asking you, whether the burden of proof was still the same. Of course, burden should kind of remain standard in time. But rather, that do you recognize that evidence now is easier to come by, right? That because of our technology, we now have emails or someone's Ashley Madison account, or a woman's easier to take her phone and maybe take a photo of bruising. That it's easier to then show to the court without having to exactly call witnesses who maybe saw someone with somebody, but that you directly have an email, being able to present that your spouse was cheating on you or a photo that they were hitting you. I think that's where he was trying to go, that it now, because of technology, may be easier to show fault because the evidence is easier to come by and present to a court.
You have evidence that we didn't have earlier, but you still have to prove that evidence up the same way that you've always had to prove it up.
All right. Mr. Sharpe, thank you.
And thank you very much.
Mr. Biederman, did you have a
Yeah, one more thing.
Yeah, Mr. Biederman, I think, has a question.
Yes, sir. And it seems like to go to Representative Moody's point, since we are prosecuting more of those cases, that would give more proof for divorce without having to go no fault. Would you say so?
Well, proof in a criminal action is not going to be coming over in a domestic case except the witnesses come to prove it up. So your proof in a divorce is still going to be what it is.
Well, what I'm saying is we're trying to we're trying to get rid of no fault divorce. So if we now have more proof for a divorce, then we won't. That makes it less likely that you need no fault divorce.
Oh, I would agree. Well, let me say this. The issue on no fault is absolutely the constitutional issue. Divorces should be the same as everything else in the courthouse. Plaintiff should have the burden of proof, and defendant should be able to either have a legal bar or show you don't have sufficient evidence to get what you're trying to get. It's that simple. It's no more complicated than that. And the fact that you've got electronic evidence that you can use now, hey, I can tell you one thing. As a trial lawyer, and I continue to be a very active trial lawyer, in fact, some of the most intensive cases I've got have got evidence, electronic and otherwise. And let me tell you something. Those cases are more difficult to handle than one that you don't have much because you've got so much you're having to deal with.
All right, Mr. Sharpe, thank you for your testimony.
Thank you,
for
Mr. Chairman.
being here.
And I hope I've answered your question.
You did. Thank you.